Hi, my name's Janae and I'm going to talk to you about whaling in the Antarctic. This is a presentation on the case Australia versus Japan, New Zealand intervening. First up, we're going to watch a short video. If you're a bit sensitive, probably look away, but I wanted to give some context for why I've chosen this topic. Okay, so what was Australia's argument? Well, in this particular case, Australia brought the dispute to the International Court of Justice, arguing that Japan's whaling program in the Antarctic was not conducted for scientific research, as Japan were asserting. Rather, it was in fact conducted for commercial whaling. Australia contended that Japan was in violation of the International Convention for the Regulation of Whaling by conducting these activities in the Southern Ocean, which is a whale sanctuary, as we've just heard in the previous video, and that it was undermining global conservation efforts to protect whales. Okay, so what was Australia's argument? Australia also argued that Japan's whaling activities were causing harm to the whale population in the Antarctic region, and that Japan should cease its whaling program in compliance with its international obligations. New Zealand intervened in support of Australia's position, reinforcing the argument that Japan's whaling program did not, in fact, align with scientific purposes. Australia also contended. So what was Japan's argument? Japan argued that its whaling program in the Antarctic, known as JAPA 2, was conducted for scientific research purposes, as allowed under the International Convention for Regulation of Whaling. Japan basically was saying that its whaling activities were carried out to collect scientific data on whales, including the population size, age, reproductive rates, with the goal of ensuring the sustainable management of whale stocks. Japan maintained that its whaling program was consistent with the provisions of the ICRW, which permits whaling for scientific research. It also contended that it was conducting research to gather valuable data necessary for the eventual resumption of commercial whaling. Additionally, Japan also argued that its whaling activities were not causing significant harm to the whale population and were conducted within the bounds of international law. Well, the ICJ begged to differ. The ICJ in 2014 ruled that Japan's whaling program in the Antarctic did not meet the criteria for scientific research, as outlined by the ICRW, and ordered Japan to cease its program in its current form. So what legal principles were used in making this decision? Well, basically the ICJ used a number of principles. They used the interpretation of treaties. So the ICJ interpreted the provisions of the International Convention for the Regulation of Whaling to determine whether or not Japan's program was in compliance with the treaty, and it examined the purpose and intent of the treaty regulating those whaling activities. The other legal principles that it applied was the scientific research exception. The ICJ considered the provision in the treaty that allows for whaling for scientific purposes. It evaluated whether or not Japan's whaling program genuinely fell within the scope of scientific research or if it was primarily for commercial purposes. It also used the good faith principle. The court assessed whether or not Japan had acted in good faith in implementing its whaling program and examined whether or not the program's design and execution aligned with the objectives and principles of the treaty. The precautionary principle was also used. The ICJ considered whether or not the precautionary principle, which emphasises the taking of preventative measures when scientific evidence is uncertain or inconclusive. It evaluated whether or not Japan had taken sufficient precautions in its whaling program to ensure the conservation of the whale species. It also considered quantitative and qualitative analysis. The court examined whether or not scientific methods used by Japan in its whaling program, including the quality and quantity of data collected, and whether these methods were consistent with genuine scientific research. So what impact is this going to have on Japan's future whaling program? Well, the immediate impact was that Japan had to cease all of its whaling activities in the Southern Ocean immediately. Japan temporarily halted its whaling activities in the Antarctic after the ICJ ruling. The ruling found that Japan's whaling program had scientific research as a pretext and that it didn't necessarily meet scientific criteria for issuing permits to kill whales. The ruling put some pressure on Japan to review and potentially modify its whaling practices in the future. So what impact? But it's important to note that the judgment did not require Japan to never whale again. It required Japan only cease JAPA 2, meaning that it may be only a matter of time before there is a JAPA 3. In other words, another program for scientific research purposes. Japan also continues to whale and conduct research in the North Pacific, JAPA 2, under special permits. In fact, the day after the judgment, its fleet left port for the North Pacific with a special permit for the lethal whaling of 102 minke whales. But it's important to note that the judgment did not require Japan to never whale again. It required Japan only cease JAPA 2, meaning that it may be only a matter of time before there is a JAPA 3. In other words, another program for scientific research purposes. Japan also continues to whale and conduct research in the North Pacific, JAPA 2, under special permits. In fact, the day after the judgment, its fleet left port for the North Pacific with a special permit for the lethal whaling of 102 minke whales. According to Japan's Ministry of Foreign Affairs, the whaling in Japan targets cetacean species whose abundance has been confirmed by the International Whaling Committee. Its total allowable catch is set within the catch limits calculated in line with method adopted. It's worth noting that recently, as recently as 2023, a private Japanese company is building a new whaling ship designed to travel as far as Antarctica, sparking fears that commercial operations could resume in the Southern Ocean. Kyoto Senpaku Kaisha announced that it was building a new mothership that can sail for 60 days and travel up to 1,300 kilometres. It's worth noting that recently as 2023, a private Japanese company is building a new whaling ship designed to travel as far as Antarctica, sparking fears that commercial operations could resume in the Southern Ocean. Kyoto Senpaku Kaisha announced that it was building a new mothership that can sail for 60 days and travel up to 1,300 kilometres. The term mothership method refers to a process in which smaller, more agile vessels are used to hunt whales, before the carcasses are returned to the mothership for freezing and storage. A spokesperson for this private company states that unless a new mothership is built, we cannot pass on our whaling culture to the next generation. Australia's Environment Minister Tanya Plibersek reaffirmed the Albanese government's commitment to a global moratorium on commercial whaling activity, while Greenpeace condemned the practice as brutal and unnecessary. Plibersek said that the government was aware of reports of the new whaling vessel, but the Japanese government had provided assurances that it had not provided financial support for the ship. So I think we can say that while this case did present a victory of sorts, the